The next case is VESTA Construction versus LOTSPEICH. Looking around the room, it looks like a senior meeting of the Bar Association. All right, gentlemen, you may begin. You may begin.
Thank you. Good morning. May it please the court, I would like to reserve 5 minutes for rebuttal. I'm John Stump, Callahan, Dietrich, and Spears. I'm here on behalf of the appellant in this case, VESTA Construction and Design, L.L.C. We're here today because the trial judge dismissed VESTA's first amended complaint against the appellee, Michael HOWE.
Mr. Stump, let me just ask you a hypothetical here, and I realize there may be a basis for distinguishing my hypo from the facts in the case, but just hear me out on it. Let's say I hire ABC Plumbing, Inc. to do a repair at my house, and they come and they repair a leak, and they do it negligently, and it's Bob the plumber who works for ABC Inc. who repairs my leak negligently, and as a consequence of that it leaks and damages the wall and damages my home, and I sue them in negligence. Do I have an action against Bob the plumber in his individual capacity, or am I only suing the corporate entity there?
Without distinguishing the facts, if the individual is engaged in conduct that's determined to be negligent, then I think there is a cause of action against the plumber. I know I see that seems to be to open a Pandora's box, but the reality of it is I think there is a cause.
Well, where is the source of the duty? You know, I mean, you got to have duty and breach of duty. When the duty arises solely under the contract, aren't you stuck with a contract action? In the case of a doctor, for example, there may be a contract with a doctor, but there's also, a doctor also has a duty in tort to, as a professional. But it wouldn't appear to me that there would be any duty extrinsic to the contract in my hypothetical.
Well, it's a little bit of the difficulty we're having on the trial level. We allege the existence of a contract between VESTA and LOTSPEICH. It has been subsequently argued, and the court has embraced the notion that there is no contract between VESTA and LOTSPEICH, that actually the contract is between Michelle Neal personally and LOTSPEICH, so that there is no contract. We've cited case law for the court that basically sets out the duty and tort on the part of many corporate employees. The first case we cited for the proposition, I think probably the most obvious, is the Walmart case, in which the manager at the Walmart was advised of a problem in the aisle.
I recognize that it is a general tort principle that an employee of a corporation who individually and personally acts negligently can generally be sued in addition to the corporation in tort. But do you have any cases that relate that to the economic loss doctrine? In other words, in a case where you can't sue the corporation in tort because of the economic loss doctrine in a contract, that you can still sue the employee that performed the contract allegedly negligently? Do you have a single case that says that?
Well, I do when we cited the cases, but I do want to, and it plays into this, we're pursuing this on the basis of the second restatement of torts relating to the information negligently supplied for the guidance of others. With all due respect, I understand that the plumber may be a hypothetical, but in our instance, we're not talking about somebody who fixed a pipe. We're talking about
someone. So it's your position that the economic loss rule has basically a huge gaping hole at the end, that you're barred from suing a corporation that you contract with for performance of that contract, but all the employees that actually worked on the contract, you can sue them individually?
Well, we've cited numerous case law that basically support that proposition. And in fact, I think even the Fifth has ruled in that same manner.
Does it matter if it's for services or for actual work performed, that is, an expert such as an accountant or a lawyer, reference, as opposed to someone who delivers actual work, for a plumber or a brick mason?
Well, all the exceptions that have been found have related to people who are providing information in some type of professional or semi-professional capacity. The cases that we cited to in terms of the exceptions.
Well, the exception is professional negligence, correct? That's the exception that the Florida Supreme Court recognized.
No, as a matter of fact, there have been instances in which professionals have not been defined as individuals who are liable in tort outside the scope of the economic loss rule. The negligent
Well,
misrepresentation.
then who would be fall under the exemption? I mean, it seems to me that everybody can be categorized a certain way so they can be sued. That defeats the whole purpose of the Supreme Court ruling.
Well, any individual in any circumstance where he's engaged in conduct in which he has agreed to perform a service for someone and agreed to use a reasonable standard of care. I suppose the rationale of the plumber would be he comes into your house and rather than negligently fixing the pipe, he leaves water on the floor.
Maybe I'm
and
missing.
clean it
Can
up.
you quote for me a case that says that the economic loss rule does not apply to the employees that perform the contract? Because that's your argument. Maybe I've missed that.
Yes, sir. The primary case is McLeod v. Barber, 5th
Is what?
DCA. McLeod v. Barber, 764 Southern 2nd at 790, 5th DCA 2000. Plaintiff sued the insurance company and the insurance agent.
Well, wasn't that a separate tort that the agent involved himself in, separate and apart from his duties?
There's nothing in the case to indicate that, Judge. The case was dismissed against the agent with prejudice for, among other things, that it was barred by the economic loss rule.
Well, the agent is not a party to
Employee of
the
the insurance
insurance contract, right?
No, he was an employee of the insurance company.
He was not an
Yeah.
independent agent?
Was not.
But he's still not a party to the insurance contract. It's a contract between the insurance company and the insured.
Exactly.
And he has some kind of duty he has a duty in advance of the execution of the contract to put the insured in the correct contract of insurance, right? So he has some duty that comes into being before the contract even comes into existence, right?
Well, just as anyone who engages in any economic activity or any other kind of activity agrees to provide a service or anything else has a duty. I mean, in this instance, they found that the economic loss rule did not bar the claims, although it may have barred the claims against the insurance company, it did not bar the claims against the agent because the complaint did not allege that the agent had a contractual relationship with the plaintiffs. That went on to cite Williams versus Bear Stearns, which was also here in the Fifth. 1998, economic loss rule did not bar claims for negligent misrepresentation and breach of fiduciary duty against employees of the investment advisor because there was no contractual relationship between the plaintiff and the employees. And I tend to agree with you. I understand your argument, and I confronted that when I prepared for today. The reality of it is that the individual, if he engages in conduct which does not meet the ordinary standard of care, or engages in a conduct which basically is a violation of the Second Restatement of Torts, he's liable in tort. And the case law is clear on that.
Okay, but aside from I understand your negligent misrepresentation theory that, which is a separate count, as I understand it, from your negligence count, right?
We alleged negligence in the first complaint. It was dismissed. We amended, and effectively, I think we alleged it as a second restatement claim, information negligently supplied.
How many counts do you have in the complaint that was dismissed?
We had one count against Mr. Howe in the original complaint dismissed, and then it was dismissed with prejudice in the second count, in the second complaint.
So that count is a negligent misrepresentation count?
Yes, sir.
Well, it's information negligently supplied, correct?
Yes, sir.
Restatement 522.
Yes. And that's essentially the difficulty we get into, and that we have had from the beginning. The court essentially ruled, and just briefly, VESTA had a contract on 55 acres in Titusville. It's $367,000. They had another 30 acres under contract for $60,000. They were going to develop this property. They asked LOTSPEICH to prepare it. Mr. Howe prepares it. He is the employee. He prepares the report. He provides the report. and it says that there are 42 acres of wetland out of the 55. 80% of the property is wetland, cannot be developed. It sets out in his report that remediation will be $75,000.
Now, the third argument that you make, which is that the negligent misrepresentation exception that the Supreme Court recognized also applies to the tort of information negligently supplied, that would apply to the corporation as well. I mean, there would be no economic loss doctrine with respect to this contract at all, under that argument.
I think that's true,
Sure.
and then you
Yeah.
probably get into the argument of whether or not the damages are in any way separate, and if they're not, then yes. I think it is a general exception, and I think the Supreme Court, over the last 3 or 4 years, has clearly broadened the scope of that and said point blank that long-recognized, well-recognized torts were not intended to be overcome by the economic loss rule. So yes, I think it would be an exception down the board. The damage claim...
So your position then is that the economic loss rule simply doesn't apply under the third argument to any contract for information. If I contract with you to do a report on anything or supply any kind of information, that's just, you can always sue in tort for negligently supplying that information.
Well, I think just as fraud and the inducement, yes, is also a general exception to the rule. I think just as fraud and the inducement...
Has any Florida court ever directly addressed that? Because I didn't see that either. In other words, I understand that there is a negligent misrepresentation exception, but this is a different tort, negligently supplying information. Has any Florida court addressed that issue with respect to the economic loss rule?
I think that the Florida Supreme Court in 1990 is the broadest one, is the First Florida Bank versus Max Mitchell. They found in that instance that an accountant was liable to the bank for negligent failure to use ordinary care in preparing the financial statements. Most of this applies as far as the law has...
But that was under their recognized exception for professional negligence, accountant, correct? I mean, that...
No, I do not believe that had anything to do with it. They found in this instance that the accountant was liable, and even though there was no privity with the bank, and they expanded it. I think the reason for the expansion is the application of Section 552 of the Second Restatement of Torts. But in each of these instances where the Supreme Court has looked at it, they have said on more than one occasion that it was not intended to do away with existing well-recognized torts such as fraud and the inducement and negligent misrepresentation.
Can the provider of the information in the contract limit his liability? And say that if I provide false information, the limit of my liability is the cost of the, there's these house inspectors out there, that inspect houses for $150 or something like that, and, before you close on it. And they always have in their contract that, our limit of liability is $150. Is that valid?
You have instances in which you have alarm companies that place those same kinds of limitations, and I think it has everything to do with the manner in which it's contracted, the positioning, the bargaining of the positions of the parties, and every other aspect of it. Whether or not to void the contract.
But if they can limit it in the contract, then there must not be any theory of liability extrinsic to the contract. In other words, that's where the economic loss rule came into play in the beginning in the Florida Power case, was an attempt to contractually limit liability and an attempt to circumvent that limitation.
Whether they can limit liability for their own negligence, I think has to be explicitly set forth in the contract. I think that's what the law says.
Well, they explicitly do it. Is it valid?
Well, but I think there's a distinction. That contract is going to have to say, you waive any claims you might have against me for negligent preparation of this report. Beyond it, I don't think that a contractual provision that says that any damage claim you might have against us under this contract is limited to $150. I don't think that limits a claim for fraud and the inducement. I don't think it limits a claim for negligent misrepresentation. It depends on how it's written, and that's the point. I think there are two tracks. If the contract says you release us from our negligence, I think you've released your negligence claim. But if it says you release us under the contract and you release us for our negligence, to me that's affirmation of the existence of two separate tracks on two separate theories of liability. And that's the position we've had all along. In this instance, we had two efforts to set forth the cause of action. The court found that we couldn't state it for two reasons. Number one, that corporate acts couldn't be imposed upon an individual simply by the affiliation of that individual with the corporation. I think we've covered that ground. I think clearly if the conduct, and the case law is clear that the conduct of the individual results in the damage if the individual actually engages in the conduct, rather than simply being an innocent member of the corporation or bystander, then he can be held liable. The second theory was the economic loss rule.
Wasn't this Section 552 intended to deal with situations where the plaintiff does not have contractual privity with the defendant? For example, you know, you have a CPA that does a report on the financial health of a corporation, and you know, does it under contract with the corporation, but third parties are provided with that information and they rely on that in making investment decisions. I mean, wasn't that what this really was intended to get at?
Well, that's not how it reads, and I don't think it was. I do think that was an issue of clarification in terms of the extent to which the reliance can be defined. And I think that's why the Florida Supreme Court ultimately embraced the second restatement as a medium ground. I think it found that basically how far you could take it out had a lot to do with not just reasonable foreseeability, but who was in the food chain. So you're right, the lack of privity is really the big issue. But if you read the restatement, I mean, it says point blank, one who in the course of his business, profession, or employment, or in any other transaction which he has pecuniary interest, supplies false information for the guidance of others in their business, is subject to liability for pecuniary loss caused to them by their justifiable reliance on the information, if he fails to exercise reasonable care or competence in obtaining or communicating that information. This court looked at this issue from the aspect of an appraiser, a property appraiser. Now, it's the best case I think I've got before the court, and that's the Albright case cited in 1990. And in that instance, the court found that a jury question was presented as to whether the real estate appraiser could be liable to the bank for the appraiser's allegedly negligent estimation of the fair market value of the real estate project, even though the appraisal was not prepared for the bank. Now, in this instance, as far as I'm concerned, we've hit that one because we've got privity. He knew, and we alleged, that he provided it to us with the express understanding that we would rely on it. He knew we would rely on it, and it was reasonable for us to rely on it. In this instance, we're twice removed. In this instance, the bank was not the party to whom he turned the report over to, but it was reasonably foreseeable in this circumstance and certainly provided for in the second restatement that the bank would rely on it. The appraisal specifically stated that its objective was to estimate the value for the purpose of mortgage financing. Update of appraisal prepared by the appraiser was addressed directly to the bank, so in this instance, he gave it directly to them. And there was evidence that the appraisal was negligently prepared. I don't think this case really takes you back to whether or not a plumber's liable. Thank you, Judge. I think in this case it really is an issue of whether or not, taking a look at all of the case law that governs these, let me do about 20 seconds, Judge. We've cited cases in our brief: appraiser liable for negligent appraisal, accountants liable for negligent preparation of financials, abstractors liable to title company for negligent preparation of an abstract, accountants liable for false audit reports under the Deloitte Touche, in which the court embraced the second restatement of torts 552, insurance agent liable to party seeking insurance, broker liable to purchaser of property. Every one of these cases addressed both issues: personal liability, economic loss rule. They all found the economic loss rule did not apply, and they all found personal liability. In this instance, we set out all the elements. We stated a claim against Mr. Howe. We were told after our second bite at the apple that we couldn't state a claim and couldn't amend a state a claim. It's de novo review. We think that the court should have allowed us to go forward. We think the case law clearly supports this, and I'll be back.
You have 2.5 minutes remaining, sir.
May it please the court. Good morning, Your Honors. Edgardo Ferreira standing in for Rebecca Kibbe on behalf of Michael Howe.
What's your name again, please?
Edgardo Ferreira.
Would you tell me, counsel, how I can distinguish the First State Savings Bank versus Albright case?
Your Honor,
The instant case?
basically it's our position here that they did not allege anywhere in the complaint that Michael Howe was individually liable for any of these torts. They're saying that he was in the course and scope of his employment, and by doing so, they waived the fact that he was individually liable for any of these
How
torts.
is that any different than this Albright and Associates case where they hire a real estate firm. It says they hire a real estate firm, Albright and Associates of Ocala, Inc. Albright was the one that actually did the appraisal. I mean, how is that? I'm not really seeing a distinction, frankly.
Well, I think the distinction is that it's a technical, what we're looking here is a technical pleading requirement.
Well, the trial judge said you can't plead here. They wouldn't even let him amend another time. They said, you're out of the box here.
Well, I think it's because they had sufficient amount of opportunities to amend.
So you're saying that they can plead this, they can plead their case and bring it within the Albright case. Mr. Stump and Mr. Spears just were negligent in the way they drafted the complaint, but they could redraft it and do it right, right?
Well, I'm saying that if they could find some way that Michael Howe did something individually negligent, then perhaps they could.
Well, I mean, this is
Saying that there was 90% wetlands when there were only 20% might be individually negligent, I guess. Wasn't that, they alleged that he was the one that did it?
Well, but it was done in the scope and course.
okay, so if Mr. Stump, if we permit him to delete that in the course of scope of employment by interlineation in the pleading, will that state a cause of action and get him by a motion to dismiss?
Your Honor, I also think that we also have to look at, if you do allow that, as they stated before, it opens up a Pandora's box. You're allowing.
All right, before you start talking about the Pandora's box, tell me how this case before us is different from First State Savings Bank versus Albright if counsel's permitted to delete the reference to scope of employment.
I think, once again, Your Honor, if I may have some time.
I mean, they zeroed us in on the case in the brief. They say it's their best case, so.
You know, I think the difference is, permit me,
If you're looking at your brief, you won't find it because
No, I'm
you
not
didn't
looking at my
address
brief, Your Honor.
any of the issues that were actually raised in the briefs.
yes, Your Honor, I understand that. I'm looking at my notes. I'm sorry, Your Honor, I'm terribly sorry, it was Albright versus,
It's First Savings Bank, First State Savings Bank versus Albright and Associates of Ocala, Inc.
yes, Your Honor.
A 5th District case, a 1990 5th District case.
You know, again, I think in this case, there has to be, I think what it comes down to, in order to present a case against a corporate employee.
Counsel, I mean, if you can't help me with this, then I'll have to figure it out myself. Did you read the Albright case?
Yes, Your Honor, I did.
And do you know what the facts of the Albright case are?
Yes, Your Honor, I did.
Why don't you regurgitate the facts here for me?
Your Honor, I'm sorry here. It's a bank sued a real estate appraisal firm and an individual appraiser for an inaccurate appraisal. And I think the difference here is that, again, I'm going to go back to the issue of the scope of employment. I think that's our argument in the brief.
Are you saying that this appraiser here in the Albright case was not acting within the scope of his employment?
No, Your Honor, I'm not saying that. What I'm saying is, in this particular case, he was working in the scope of his employment. Also, I don't believe that the restatement of torts here really applies. I think what we're looking at is it should be negligent misrepresentation as we presented in our brief, in part 3 of our brief.
Are you done with distinguishing the Albright case? You want to move on to a different issue?
Your Honor, I would like to.
Because you haven't convinced me. I want to give you a fair shot at convincing me here.
Your Honor, if you allow me to, I'll be able to brief the case and present it supplementally to you at another time.
Yeah, I tell you, I mean, I don't mean to be critical, but when the appellant says in their brief that this is our best case, it's on all fours, it's from this district, you're bound by it, if you're going to get around it, you got to give us some help with that, counsel.
Yes, Your Honor, and I think, once again, what I'm trying to say is that in this particular case, it's all about individually being presented. The plaintiff, the VESTA, saying that he was done, it's in the scope and course of his employment, and as opposed to individually. And I think that's what we briefed what we stated in our brief.
All right, sir.
And, Your Honor, I think that's what it comes down to. VESTA alleged that Howe negligently provided inaccurate environmental assessment. He stated that he falsely represented the amount per acre that would have to be spent in mitigation costs, and Howe knew that VESTA would rely on the assessment, and there was and that VESTA relied on the information provided. However, there's nothing in there to present that there is a duty, or there was a duty owed, or the duty was breached. According to McLeaven versus Peeler, a plaintiff must allege that the defendant, in his individual capacity, breached a duty, and this complaint does not do so. VESTA has failed to allege sufficient ultimate facts that Howe, as an individual, breached any duty to VESTA, or that duty was breached through his
If
personal
they had
actions.
argued he deliberately did that so that the property could be sold at a fire sale, so that his cousin or someone else could buy it, develop it, and that he would get a kickback or he would be part of the development, would that be enough?
Well, Your Honor, I think that brings it into another realm.
Well, my question is, would that be enough? Would it move it to another round?
Yes, I would, if it was just like that, yes.
Why?
Well, because then at that point, you're alleging that he did something individually incorrect, that he did something wrong. In this case, that never occurred.
He did a separate tort that would then allow the contract not to bind him. Is that your argument?
Yes, Your Honor.
Now, here are you arguing that he was just bad in his work and that the contract now protects him?
No, I'm not saying that at all. I'm not saying he was bad
What are
at
you
his work
saying
whatsoever.
then?
I'm just saying that they did not correctly plead they did not plead sufficient ultimate facts to provide a negligent claim against Michael Howe.
What else would they need?
Your Honor, it's not for me to say what they would need, but they would need
Even
to.
if I ask you?
They would need to somehow present enough ultimate facts to allege that he did something wrong individually outside of his scope and outside of his employment with LOTSPEICH.
Like deliberately lying about how much is wetlands, how much needs to be?
Correct. That would be something that they could allege. And at this point, that's all I have for you.
Thank you, counsel.
Very briefly, Judge. The appellee's brief takes the same position they continue to take on the trial level. We're still back down there on our fourth amended complaint in an effort to bring a claim against LOTSPEICH. They've alleged in appellee's brief that Michelle Neal, president of VESTA, entered into a contract with LOTSPEICH. They continue to argue that there is no contract between VESTA and LOTSPEICH. I think it's an important point because the essence of their effort to have us dismissed is the contract prevails and therefore you don't have any independent tort claims. They continue to argue there is no contract. There was no request to dismiss this with prejudice on the trial level. The court simply dismissed out of the blue on the second go-around. There are numerous 50CA cases that basically say that there's liberality involved in that and we should be given an opportunity to amend. We would ask that the trial court's order be reversed and be allowed to go forward against Mr. Howe. Thank you, Your Honor. Yeah, unless there are any other questions.
Are you agreeing that there may be a technical pleading? Because I agree with you, if that's the only issue, if it's a technical pleading issue, that it would be an abuse of discretion not to allow you to amend at this stage. I mean, and that's their only argument, that it was a technical pleading deficiency. Are you admitting that there's some need to amend the complaint in order to
No, Your Honor.
state a cause of action under 552 of the restatement?
Not at all.
Okay.
We think that we absolutely set forth the cause of action. The sending it back down for amendment, we don't think amendment's necessary. We set out all the elements. We think we stated a claim. If the argument is that somehow there's some alleged deficiency in the pleading which could be reflected, then obviously we feel that we should have been allowed to do that. But we're not taking that position. We stated a cause of action on the trial level. We should have been allowed to go forward. Thank you.
Thank you.